So I'm going to finish off with some key changes and key places to plan for in the year ahead. I'm going to look at what we know will happen and what we think might happen, and just wrap up with a few cases of interest. So, of course, we can't have a session today without talking about Brexit. And as we know, there's going to be no immediate changes to workplace rights from the 1st of January. There has been no official statement regarding any planned changes to employment law. What the government has said is that it's committed to ensuring that UK workers' rights do keep pace with those of EU workers. And we may possibly see some changes coming out of the trade deal negotiations, which Jane mentioned earlier. Now, it has been suggested that the government might look to change aspects of UK law with a basis in EU law, things like TUPE, working time regulations, collective consultation requirements. But we really are speculating here. So it really is a question of watch this space. And I think the general view is that this is probably not at the top of the government's to-do list right now. Of course, when we get to January, we're going to see a review of the extended furlough scheme, which will now run until, which will now run until the 31st of March 2021. And then the government will decide if employers should be required to contribute a proportion of employees' wages. Obviously, as employers, you'll need to assess how any changes to the scheme are going to impact your business. And of course, you've got to plan for when the scheme eventually comes to the end from April. It's not clear now what form the job support scheme will take. And that's the scheme which the government proposed they would cover 1/3 of the difference in actual versus normal pay for employees on reduced hours. Because all the guidance has been removed from the government website, it's possible that that scheme won't now be rolled out at all. But again, we'll need to see what the position is. Now, hopefully, most of you will be well ahead with your planning for the introduction of the of payroll rules for the public sector, because as you'll know, those were delayed relatively last minute and they were due to come into play last April. Now, the IR35 rules apply where an individual personally performs services for another person using a personal services company. And at present, in the private sector at least, it's the responsibility of the personal services company to determine whether there's deemed employment and if IR35 applies. Under the new regime, for services which are provided on or after the 6th of April next year, the onus is going to shift. So it will be the end user client who makes the status determination, and responsibility for accounting for tax and national insurance will shift to the fee payer. So if the rules apply to you and you haven't done so already, you need to carry out an assessment to determine whether the new rules do apply to your independent contractors, and you need to use the government CESS tool that you'll find on its website. You'll also need to review the contracts and pay arrangements for anybody affected under the rules. And it's a good idea to have early discussions with your contractors to ensure that you have continuity in terms of your resource, or to flush out where you may need to look for alternative resource if contractors don't accept the terms that are on offer. Now, I just want to mention the new employment tribunal rules. They're actually already in force. But I mention them because if any of you are experiencing the joys of litigation in the tribunal at the moment, you'll be aware of some really significant delays. And apparently there is a backlog of 45,000 cases. So we're only going to see the impact of these new rules in the current, in the next year. Now, the aim was to really streamline things like the ACAS pre-claim conciliation process, case management hearings, and to reduce bureaucracy. And we also know that the government is working on how better to support remote hearings. They are, in our experience, getting better at doing that. But we wait in anticipation and I think in frustration at the current chaos and confusion and the lack of communication that we're getting. We've written a little bit about the rules on HR law, so if you want some more detail, that will be the place to look. Now, in terms of what we think might happen in the year, there's a much longer list. So I'm going to start with non-disclosure agreements. In July 2019, the government announced plans for new legislation prohibiting NDAs being used to prevent individuals from disclosing information, for example, to the police, to regulators, or to legal professionals. And according to the press release, the updated legislation is going to make it clear, a requirement that it's made clear in contracts and settlement agreements that employees are not prevented from reporting to those particular bodies. And also it's going to require that individuals who sign NDAs get independent legal advice on the limitations of the confidentiality clause. So in the same way that it's a requirement to have legal advice for an effective waiver under a settlement agreement. We also understand that there will be new enforcement measures introduced. So for example, it's likely that an NDA in a settlement agreement that doesn't follow the new legislation will be legally void. Now, we don't know when this is going to come onto the statute books. We understand it will be when parliamentary timing allows, so who knows. But you've probably become aware that solicitors have been issued with warning notices by our regulator, the SRA, on the use of non-disclosure agreements, which make it clear that we may be disciplined if we use them improperly on behalf of our clients. So if you've been engaging with us or other lawyers around settlement agreements, you probably have seen changes introduced or been asked to make changes to settlement agreements, for example, to make it clear that employees won't be prevented from reporting to regulators or law enforcement agencies, and that they won't be prevented from whistleblowing. So if you haven't done already, now is a good time to update your existing template contracts and settlement agreements because you will be asked to have these changes, and you will be eventually expected to have these changes in your documents. So on the subject of whistleblowing, the UK all-party parliamentary group on whistleblowing was set up to review our whistleblowing regime in the UK and the protection it affords or doesn't to whistleblowers. And they published their first report, which was included a proposed 10-point plan. Now, just a few highlights from that. It proposed extending the definition of whistleblowing to include harmful violations of integrity and ethics, even though those are not criminal or illegal. It advocated meaningful penalties and a review of compensation and how it is calculated. And it's also advocated the creation of an independent office of the whistleblower with power to set standards, enforce protections, and administer penalties. And it's made clear that its recommendation is that that applies not only to individuals, to organisations, but also to individuals within organisations. So again, another one where we're not clear when it will be adopted, but we expect some consultation on this in the new year. There is also a proposal to extend the time limit for pregnancy and maternity discrimination claims. This came out of a House of Commons petition committee who published a report making various recommendations to amend family-friendly leave and rights in the light of the COVID-19 pandemic. Most of those have been rejected except this one, and we're expecting a kind of response to that report to be published shortly. Now, perhaps the biggest piece of legislation we're expecting this year is the Employment Bill 2019, which was announced in the December 2019 Queen's Speech, and we expect it to be published in the coming year. The measures which are likely to be included in the bill are pretty wide-ranging, and several originate out of the government's Good Work Plan, which was published in 2018, and that followed the Taylor Review on modern working practices. So some of the things that we're likely to see the introduction of a single labour market enforcement body, which is going to be put in place to ensure that vulnerable workers are better informed of their rights, and also to help support businesses to comply with their legal requirements. We're likely to see a new right to request a more predictable and stable contract after 26 weeks service. And that's really aimed at those employees engaged under contracts with variable and unpredicted hours, like people on 0 hours contracts, for example. We anticipate that flexible working is to be made the default position unless an employer has good reasons not to allow this if it's requested. And we're likely also to see the extension of redundancy protection so that it will become automatically unfair to dismiss a woman by reason of redundancy if the dismissal occurs not just during pregnancy or maternity leave, but also in the 6-month period after the end of pregnancy or maternity leave. And there will be some exceptions to that, for example, if the business is closing down in the place where the woman's worked, or if there is really no suitable alternative employment that she can be offered if the work that she's employed to do is ceasing. Now, this comes out of the research carried out by the Equality and Human Rights Commission, which identified that during the last recession, women with childcare responsibilities were at a significantly greater disadvantage than men. And their research found that around 1 in 20 mothers were made redundant at some point during their pregnancy, maternity leave, or shortly after their return. We are also expecting some new rights for parents of children in neonatal care. So the right to take an additional week of leave for every week that their baby is in neonatal care, up to a maximum of 12 weeks. That leave will be added to the end of a period of maternity or paternity leave. And there will likely be some pay at the minimum current statutory rate for those with significant service, so 26-week service, and also who earn above the minimum pay threshold. And then finally, a right to have a week's unpaid leave for employed carers. And there was a consultation on this which closed in August 2020. The government response to that is not yet available. So again, not sure quite what form that will take, but we do expect it to come onto the statute books. Now, very briefly, just 3 cases I want to highlight because we don't have much time available to do more. The first one is a really important case which was actually heard this year, but again, it's one of those things we're likely to see an impact on in the year ahead. So these are cases around post-termination confidentiality restrictions, which seek to prevent people from disclosing and using confidential information after they've left employment. And in P14 medical, the restriction which was contained in the relevant contract, which was being examined, was really something that we would probably regard as pretty standard post-termination restrictions that most lawyers will recommend and most employers have in their contracts and settlement agreements. But it was held to be too wide because it was purported to run indefinitely, and that it went beyond covering trade secrets to confidential information relating to the company's business, products, affairs and finances. And the judge held that it was only trade secrets which could be protected, not information which was, in their words, merely confidential. And the Investor Textiles case preceded that one and was on very similar lines. Now, in each case, the judge held that in the particular clauses it was looking at, it was not possible to take out the offending words in such a way that it left an enforceable restriction. And so that suggests to me that in the new year, to-do list for you, you need to look at your confidentiality provisions in your template documents and redraft them carefully so they can be severed if the courts reinforce this approach to avoid sort of being left with much less protection than you thought you had. The second case to mention is the Uber case. The Supreme Court heard the case on the worker status of Uber drivers in July 2020. Still haven't issued their decision. Uber are seeking to convince the Supreme Court to overturn the Court of Appeal's decision that Uber drivers are what we call Limb B workers, which entitles them to certain statutory rights, including the right to be paid national minimum wage and to take holiday. And obviously companies and gig workers alike are watching that with interest, given the potential legal and financial implications for both sides. And finally, a working time case, Flowers. This looks at the question of whether holiday pay should be calculated to include regular voluntary overtime. And obviously that will increase the cost of holiday to pay potentially. Yes, says the Court of Appeal, and the Supreme Court is going to decide that in June 2021.